statute and they'll say, what did Congress mean? What did the legislature mean? So they're always trying to figure out what somebody else meant when they enacted the statute. Unless it's absolutely clear in the statute, there's no ambiguity whatsoever, then they may not even ask what the drafters meant. They'll just say, it's so clear, we understand. But if it's ambiguous, usually a judge will then say, well, let's look at the legislative history, let's try to understand what was intended. That's not what the common law does. The common law is the judge is not interpreting what someone else has written, but they are making the decision themselves. In one of my books, I talk about the different kinds of common law judges, and I talk about some of them are very conservative, and what they do is that I call them formal judges, and what they do is that they look to the past. They think that the answers to all legal questions are found in the law library or on Westlaw, where you can do legal research. And so we don't want to go in front of those kinds of judges if we can avoid it, because there are no precedents that will really help us, and that a chimpanzee or another non-human animal has never been held to be a legal person. There are other judges, what I call substantive judges, who don't so much care about what's gone on in the past. I mean, they'll look at it, but they might care about public policy. They want to do what's good. They see justice as being good. What's good? Or principal judges, they see justice as being what's right, what's morally right. So you have kind of three different kinds of judges. One judge will say, we view law as a formal judge. We view justice as being certainty, stability. We don't care if the law is right or wrong, but the fact is that everybody understands that's what it is. And stability and certainty is our primary legal value. Then the two kinds of substantive judges, you have a policy judge who says, we don't really care what's gone on before, but we want to do what's good for society. That's what we think justice is. And then a principal judge would say, we don't much care about what's gone on before or even what's good. What we see justice as is doing what's right. And so we spend a lot of time trying to think about where we might find judges like Lord Mansfield who will do what's right, because we think that our arguments are not only legally right, but that they're morally right. And we want judges who, if they agree with us, will then rule in our favor, ultimately, at the appellate levels. Again, a lower court judge is bound by what the higher court judges in his or her jurisdiction have done. And so it's unlikely that he or she will decide to step forward and be the first judge to say that a non-human, a chimpanzee, is a legal person for purposes of habeas corpus, until he or she gets some guidance from the higher courts. So that's why we're kind of going through the lower courts, understanding that we're likely to lose, but we're hoping that we lose. We lose on the ground that chimpanzee, like any non-human animal, is not a legal person for purposes of habeas corpus. We understand that. In our oral argument, the judge was asked us repeatedly, are there any cases up there that directly support you? And the answer is no, there aren't any. There are lots of cases that indirectly support us, or support something that is associated with us, but there's never been anyone who's ever claimed that a non-human animal is a legal person. To our knowledge, there's never been anyone in the English-speaking world who's ever made that kind of a claim. And it's only the boldest lower court judge who's going to say, what a great argument, you win. We're going to be putting up the transcript from our legal argument in the next few days, and look at the last paragraph. The judge said, what a great argument, you lose. Which was more than we were expecting.